Okay. Am I audible to all? Hello. Am I audible to all? Hello.
Yes, sir, you are audible.
Okay. 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 So today from Institutional Innovation Council, Sri Ramakrishna Institute of Science and Technology. Today our topic is IPR and the patent process. Our respected speaker, Professor Roshan Kishan Bonde. He is the Assistant Professor of Electronics and Telecommunication Engineering Department of Dr. Babasaheb Ambedkar Technological University, Maharashtra. He is also the Innovation Ambassador and Institute Innovation Council member. He has experience more than 10 years. He is the executive member of International Association of Business Researcher, Economist and Statistician, life member of Association of IQAC Professionals, professional member of International Association of Scientists and Technocrats. He is a member of MHRD's Innovation Cell, NISP Policy Implementation and Formulation of Dr. Babasaheb Ambedkar Technological University, member of Global Professor Welfare Association Forum, IEEE collaborated, reviewer for International Conference on Telecommunication and Signal Processing, IEEE. He is the organizing committee member of Faculty Development Program on Cybersecurity, Artificial Intelligence, Blockchain, Cybercrime and Digital Forensic, Innovation Management, and many more. Coordinator of Entrepreneurship Development Program, mentored students and communicated internship and employment opportunities through TIE Sustainability Summit. He has research publication at national and international journal and conferences. He has been honored as the Changemaker Award from Yuva Mentor in recognition for outstanding and appreciable work in innovation and education at International Summit Innovative Educators. He has Outstanding Mentorship Award at Global Leadership Conference and Award to 2022. He has published two books on Introduction to Design Thinking and Performance Plasma Biosynthesis Array for diagnosis of lung cancer using machine and deep learning models. So, on behalf of Sri Ramakrishna Institute of Science and Technology, I, Abhinandan Sharkar, welcome you, sir, for your session today, and we thank you for giving us your time and sharing your knowledge. And I hand over the platform to you for your session.
Thank you, Abhinandan, sir. And good evening to all present via virtual platform. I also thanks to Sri Ramakrishna Institute of Science and Technology, Kolkata, for giving me opportunity to deliver a talk, expert talk on IPR and the patent process. Thank you, sir. Am I audible? So please allow me to share the screen. So my screen is visible to all.
Yes, sir, it is visible, sir.
Okay. So thank you, Abhinandan, sir. You already given a lots of introduction of me. So without wasting time, we move towards the topics: what intellectual property rights, IPR, and patent process. The objective and the plan of presentation is to give the general introduction to the concept of the intellectual property rights, their roles in technology transfer. The plan of presentation is the different kinds of IPR, rationale of protections, IPR licensing technology agreement, and the IPR process, how to file a patent. So basically, there are the three types of the properties, like movable property, which includes the car, pen, furniture, and dress. Then immovable property includes the land and the building. And the last is what intellectual property that we have discussed about the literary works and the inventions. Basically, the intellectual property rights are the absolute rights over the creation of mind. The creators have IP rights over their creation work, such as invention, lyrics of song, photographs, etc. Without the need to observe any formalities like registration. Essentially, these are the rights to stop the others from copying or the counterfeiting. The intellectual property is the property created by application of the human minds. The intellectual property rights are categorized as physical and non-physical. The non-physical in nature that derive the values from the ideas. In the knowledge age, the IP is a key to techno-economic growth. Okay, and they are territorial in nature. The one question may arise that why IP protects? Why protect the IP? This question may arise in the mind. So for what purpose, that why should we protect the IP? Because the legal recognition to the ownership of the new ideas and the design is required. The second one, it is the right to stop the others from exploiting the owner's property. Then for the commercialization, it requires to enhance the revenue and the market domination. The IPR can be treated as a currency that can be sold or licensed to others, provided certain conditions are to be met. The keeping also it keeping away from the competitors, and it encourages the creativity and the innovation. So that's why the protects IP. The intellectual property short includes the rights relating to the literary, artistic, scientific work, invention in all fields of human, already told you, the scientific discoveries, industrial design, trademark services, and commercial names and the design. The protection against the unfair competition. This was the generalized meaning of the intellectual property. These are the international treaties. The basic principle is what IP is what contract between the creator and the sovereign state, means protection for the revelation. It is also a balance between the rights of the creator and the public interest for rights and the limitation and the expectations. Okay. It can be bought, sold, licensed, exchanged, and the given away. The owner can prevent unauthorized use and can take a legal action in case if someone else uses it without the permission of the owner. So these are the basic industrial properties. Okay, and the intellectual properties are categorized as copyright and related rights and the industrial property. The industrial property includes the patent, industrial design, trademarks, GI, that's what called as graphical indications, layout design for a topographic of integrated circuit, trade secrets, and the protection of new plant varieties. These are the IP laws of India. The Copyright Act 1957 is for higher education department. For 1970s for industrial policy and promotion. Similarly 2000 and 1990 for design, patents and the trademarks. For the GI, that is geographical indications of the goods, it is the Act of 1999 for the industrial policy and promotion and like. So our first topic is what major intellectual properties is copyright. Okay. So what is copyright and related rights? The basically it is a original literacy, dramatic, musical, and artist work. If we go for the copyright, what it means, the ideas expressed in the material form, that is type of work, and no copyright in ideas or the factory. The cinematography, photography, the artist work completely, the sound recordings is under the copyright. There are two kinds of rights. First is moral rights and another one is economic rights. The moral right protects the personality of the author and economics right brings the economic benefits to the author. The moral rights is the rights of the authorship. It's a right of integrity and the inalienable rights which includes the moral. The economic rights are the rights of the reproduction, that is, making copies. For example, an edition of a novel. We can make a different novel, edition of a single novel, but it should be copyrighted. It should be copyrighted. Right of the distribution and the right of communication. So these are the basic first economic rights. The another economic rights are adaptation rights, right to make a cinematograph, film, or the sound recording that comes under the copyright part, the translation rights, rental rights, and the resell the rights or the original artist work. Then ownership of the right, if it is a literary, then ownership goes to author. If it is drama, then it is goes to dramatist. If it is music, then it goes to composer of the music. If it is artist work, then artists like a painter, sculptor, and the architect. If it is comes under the artist work. If it is photographic ownership, then it will goes to photographer. If author of a computer program have to get a ownership, then it is a person who causes the work to be created. Then in case of cinematograph film, it is completely ownership is given to the producer. And in case of a sound recording, all complete ownership is given to the producer of that sound recording. Then author as a owner of the rights, what are the expectation in the course of employment? It is an employer. Employment by newspaper, magazine, employer has publishing the rights, other rights with the authors. They can have the rights to the author. Photograph, painting, cinema for valuable consideration. It is a person who pays the money. They can get a authorship of ownership. If lecture delivered in a public, then person who is delivering that lecture, he as the owner of that particular rights. Then for the government work, government is the owner. For public undertaking work, the public undertaking person is the owner. And the work of international organization, that self international organization is the owner of that particular rights. Then work of apprentice means to teacher. The ownership is given to the teacher. If the teacher is writing a book, then teacher, because he is employed to teach and not write. Okay. So in case of this, teacher is a owner of that particular writing the book. Question paper, completely paper setter. Who is responsible to set the paper is having ownership of that particular question paper. Then encyclopedia, dictionary is completely editor. And in case of music, contract by the film producer, completely film producer is having a ownership. So for securing copyright, it is a formality for pre-protection and the voluntary registration is under the 44 and 45 section. The registration does not a matter of a law establish that what is registered is in fact and in law copyrightable subject matter. Basically, what is the duration of copyright? Means if we file a copyright, then what is the complete duration? So completely 60 plus 60 years of life for that particular copyright for literacy, dramatic, musical, and the artist work. And for all other works, it is 60 years from the date of publication. Okay. So the work of government and the organization is comes under the copyright duration. Okay. And the related rights of the copyrights are the rights are granted by law to communicators of the work to the public, performance, and the broadcasting organization. Okay. Then patents. A Supreme Court said that the patents covers anything under the sun that is made by the man. What is the statement? Please listen. The Supreme Court has said that the patent covers anything under the sun that is made by the man. It is an exclusive right granted for an invention. Okay. Must fall within a 5 statutory classes. Basically, process, machine, manufactured items, composition of matter, and new uses of any of the above. I will repeat. The patentable fall within the 5 statutory classes as process, machines, manufactured items, composition of matter, and the new uses of the above. And what actually non-patentable? Any artist creation, mathematical formula and algorithm, natural occurring organism, law of nature, abstract ideas, natural phenomena, treatment process, harmful invention, and anything prohibited by the national patents law. So, in short, and the period of the patents is 20 years. So, in short, I will explain you what is patentable in India and what should not be patentable in India. Method and process is patentable. Apparatus, machine and product is patentable. Substances is patentable. Then pharmaceutical is patentable. Man-made microorganism is patentable. Biotechnology process is patentable. Design is patentable. That's it. So these are the subject matters which are patentable in India. Then what is not patentable in India is abstract, law of nature, algorithm, softwares, business process, scheme rule, mental act, method of playing games, integrated circuit topography, medical treatment procedure, plants, animals, work of art, traditional knowledge, atomic energy, and public order or morality. So these are the subject matters which are not patentable in India. So these whole slides come for that. So conditions of patentability means novelty. Inventions not known to the public prior to claim by inventor. Then invention would be obvious to a person with ordinary skill. Invention can be made or used in any useful or practical activities at distance from purely intellectual. Grant of patents. Patents are granted by the National Patent Office, NPO, after publication and substantial examination of the application. I will later told you that what are the steps to file the patent. Okay. In India, provisions exist for pre-grant and post-grant opposition by the others. Okay. They are valid within the limits of the country. Okay. Foreigners can also apply for the patents. Invention that I already told you, which are not patentable in India. Okay, already machine giving more than 100% performance, Newton's law, these are not be patentable because someone have already worked for that inventions. Okay, so again, these are the gambling machine, device for housebreaking, biological warfare material or device, Terminator game technology. It will not be patented. Okay. So again, a mere agreement or rearrangement or duplication of known ideas, uh, each functioning independently of one another in known way, they are not patentable. A bucket fitted with torch, an umbrella with fan, a clock and radio in a single cabinet, a flour mill provided with sieving. So these are the examples that are not patentable. Method of agriculture and horticulture, that is cultivation, that is plant, and that will not patentable also. In whole or any part thereof other than microorganism but including seeds, varieties and the species and the essentially biological process for production or propagation of the plants and animals is not patentable. Clone and new varieties of the plant is also not patentable. That I already told you that what are the subject matters which are patentable and which are not patentable. Also told you that the any software or any computer written program is not again patentable. Now, industrial design. Industrial design means what? It is only the features of the shape, configuration, pattern, ornament, or composition of lines or the colors that comes under the industrial design. So these are the consumer products. See, this is a brush, this is a paint brush, this is a bat, this is a scissor, uh, this is a Kong pen, okay, press, pen box, watch. These are the consumer products. Okay, they are having a shape, they are having a size which is called as an industrial design. Then if they are the pharmaceutical products, that's what injections, then tablets, okay, then these are the bottles where we are putting up URI. Then textile or jewelry or ornaments, I have already told you, which comes under the industrial design. So diamond and these are the ornaments which comes under the design industrial. Rights of the registered proprietor. The proprietor of the registered design has the exclusive right to apply the design to any of the articles in the class in which the design is registered. And the period of protection is 10 years and it is extendable by 5 years. Means only 15 years we can design. What is excluded? Any mode or principle of construction or anything which is substances a mere mechanical device which is excluded. Trademark is also excluded. Artist work is excluded and property mark is excluded for the industrial design. What is not registrable? A design which is not new or original. It is not registered. A design which has been disclosed to the public anywhere, which is also not registered. And a design which is not significantly distinguishable from known design. Means if it is a design similar to the prior design which uh, other one have already registered, so that thing we can't register. A design also comprises or contain the obscene matter that also not registrable and which is contrary to the public order or morality, which is also not registered. So in short, these are the items which are not registrable. Then trademarks. What is trademark? It is a name of enterprise or a mark capable of being the represented graphically, distinguishing the goods or the services of a person from those of the other. For example, Lux, Godrej, TVS, Telco, Apple. So basically, the trademarks can be a sign, words, letters, numbers, drawing, pictures, colors of colors or combination of colors, shape of goods, graphical representation, or packaging. Any combination of the above is applied to an article or a product for trademark. Okay. Then registration of trademark. It is valid by 10 years and we can renew after 10 years. Okay. Suppose in suppose we are considering an example of Coca-Cola. No? Everyone knows the Coca-Cola bottle. Yes. Please answer. Everyone knows the bottle of Coca-Cola cold drink. Yes. Yes, Black. Am I audible, na?
Yes, sir.
Yes.
Sir, audible.
Yes, yes. So you all know the bottle of Coca-Cola, that tea.
Yes, sir.
Yes. So if we consider all the matter on the Coca-Cola, so it includes all the written words Coca-Cola, which comes under the brands or logo, which called as a trademark. Okay. Then ring or pool cans on the top of the that till there is a ring or pool can is there, which is comes under the patent. Okay. Then formula recipe comes under the trade secret. Okay. Then that Coca-Cola image is also there. That image or content which is called as an copyright. और कोई Coca-Cola कहीं पे हमें दिखाई देता है क्या? वो उनका ब्रांड है, करेक्ट? देन बॉटल और कैन जो डिजाइन होता है कोका कोला का बॉटल या फिर जो कोका कोला का कैन होता है दैट कम्स अंडर द डिजाइन पार्ट. So this comes under the one roof which is called as an IP. Okay, so there are the different types of IPs for a product which comes under this. You in simple word you can call as the ring fence of the IP. Okay, which includes all that is brand, then ring, then formula recipe, image, and the bottle shape or bottle design. These can comes in under trademark, patent, trade secret, copyright, and design, respectively. Getting everyone. So these are the different kinds of trademarks, marks on goods, services. Okay. So Woolmark is again one of the trademark. And service mark include the banking, education, finance, insurance, real estate and entertainment, repairs and the transport, etc. There comes under the trademarks. The collective mark is a mark that distinguishes the goods or services of the member. Who own the collective mark is the association of the person. It could be manufacturer, producer, supplier, traders, or the other professional bodies. Okay. So everyone getting what is patentable and what subject matters are not patentable. If having any query, ask me at the end of session. I will again tell you what the subjects matter are patentable and non-patentable. Don't be confused. In India, in US, there are the different types. Okay. So the design patents are comes under the ornamental design, shape of an invention, configuration. The utility patents are any new invention, functional improvements, and the new variety of asexualized reproduced plants is also comes under the patent. Okay. So I have told you that the Coca-Cola for soft drink is a well-known mark. Uh, Toblerone is the triangular shaped chocolates. Okay, and the Godrej, General Electric. This is a symbol of General Electric, Godrej. These are also a well-known trademarks. Forms of trademarks. It is a it can be visual, it can be audio, and it can be olfactory. Okay, visual 2D, 3D form in words, in letters, in numbered, in drawing or symbols form. Okay, audio, sound or musical note can be there, and olfactory is the we can have smells as a trademark. What is protected and what is not protected? Right to use trademark in relation to goods or services as registered are protected. Okay, and the state emblems, official hallmarks, emblems of intergovernmental organizations, they cannot be used as a trademark. Then geographical indications. Okay, so before go for geographical indications, tell me what is famous in Kolkata? Yes, yes, students. What is famous in Kolkata? Kolkata is well known for. Yes, Kolkata is well known for. Yes, Silk sarees from yes. Silk sarees from yes class. Bhujia is from Kolhapuri chappal is from. Answered any one of the question. Oranges are from yes class. Anyone I said anyone. So how I can get whether you are getting all the thing?
Participants,
Yes.
please answer what Sir is asking.
Silk saree is from. Tea is from. Bhujia is from. Kolhapuri chappal is from. Oranges are from.
You
I
can
will tell
respond
you.
in the chat box also.
I think so, sir. They don't know. Actually,
Yes, sir. It's
yes,
a
sir.
very new
They don't
topic to
know.
them. Yes,
Yes,
sir.
yes. No issue. The oranges are from Nagpur. The Kolhapuri chappal is from Kolhapur. The bhujia is from Bikaner. The silk saree is from Kanchipuram. Tea is from Darjeeling. Okay, and the Alfonso mango and so on. Means the product which gives a indication, geographical indication to particular state or particular place is called as an geographical indication of the goods. Okay. So, what is geographical indication? It is an indication which identifies the goods as the agricultural goods, natural goods, or the manufactured goods. Okay, where a given quality or reputation or the other characteristics of a such good is essentially attributable to its geographical origin. Whatever the other parts, that is, suppose I told that Alfonso mango from Konkan. Okay, so in Kolkata also mangoes are getting, but the same as a Hapus mango is getting in Kolkata. No, it is from where? It is Konkan. So it is a geographical indication for the Konkan. Okay. So like a Bhujia for Bikaner, Kanchipuram silk sari. So this is called as a geographical indication. So that explanation clarifies that GI need not be a geographical name, but it can be taken as a goods. Okay, goods includes the goods of handicraft or of industry and also a food stuff. कुछ भी हो सकता है, handicraft हो सकता है, industry matter हो सकता है, food stuff हो सकता है, anything. It can be anything from which we can identify the section. In India, the geographical indication have to be registered. The geographical indication registry examine and publish the application before the registration. And again, validity for the GI is 10 years. After 10 years, we have to renew it. The exclusive right to GI indication on the goods and the right to obtain the relief or infringement of the geographical indication. These are the rights for the. Then semiconductor integrated circuit layout and design. The protectable layout or design, original and novel layout design of a semiconductor integrated circuit can get protection through the registration. Again, the validity for the layout design is of 10 years. Registration is done after the examination and publication of the application. Not registrable design, not original, you can't register as a design, has been commercially exploited anywhere in India. That layout design also cannot be registered. Not inherently capable of being the distinguishable from any other registered layout design. Means if anyone registered a layout design and अगर उससे कुछ different नहीं है, so हम लोग उसको as a register नहीं कर सकते as a design. Then trade secrets. The trade secrets are some invention, data information that cannot be protected by any of the such available means of IPR. Okay, so such information is held confidential as a trade secret. It can be an invention, it can be an idea, it can be a survey method, it can be a manufacture process, it can be a chemical formula, it can be a recipe of anything. Okay, and it can be a database. So that cannot be registered, but it can be made a secret part. So when trade secrets are preferred, when invention is not patentable, means there is a chance of someone to what stole that stolen your idea. Okay, so in that condition, the trade secrets are to be preferred because up to the patent completion process, that can be make a trade secret. Patent protection is limited. I already told you that it is limited to 20 years. When the secret can be kept beyond that period. हम 20 years के above trade secret ये रख सकते हैं. So it doesn't matter. So when the cost of patent protections are prohibitive, okay. So when it is difficult to reserve the engineer. Then plant varieties and the farmers' rights. The protection of the plant varieties, I told you that plant is not patentable. Okay, plant agriculture are not patentable because registrable varieties and the criteria. Okay, so if it is novelty, distinguishedness, uniformity and stability, that can be comes under the new varieties. And extant varieties means distinctiveness, uniformity and stability, that comes under the extant variety. Who can register? The breeders, the farmers, the universities, and the agriculture institutes can be registered. What is the period of protection? It is 15 years for the annual crop and 18 years for the trees and the vines. Rights of the breeders, the production, sale, marketing, distribution, export, and the import. These are the rights of the breeders. What are the farmer rights? To save, use, sow, reserve, exchange, share or sell his farm, produce including seed in the same manner he was entitled earlier. Seeds for sale should not be branded. Okay, so he can be rights. Then researcher rights, free and complete access to the protected material for research use in developing the new varieties of the plant, having the rights of the researcher. Then international organization. So these are the two international organization in intellectual property. First in WIPO, that is World Intellectual Property Organization, and second is WTO, that is World Trade Organization. Then IPR licensing and technology transfer. Means license is a permission granted by an IP owner to another person to use the IP on agreed terms and conditions. While we continue to retain ownership of the IP, okay, licensing creates an income source. It establishes a legal framework for the transfer of technology to wider group of researchers and the engineers. The licensing conditions of the IPRs are: owner of IP preferred to transfer technology through license agreement. All rights or limited rights can be licensed, can be exclusive or non-exclusive or sole matter. The royalties can be upfront and the part percent per production per se. Needs to be careful about the competition law. Is licensing profitable? Yes, it is profitable, and some of the companies are also generating revenues from the licensing. Okay, so one thing. So these are the different IPs, types of IPs, and what is protected under what, under one roof. What is patents? What is the duration for patents? What is trademark? What is the duration for trademarks? What is patentable subject matters? What are not the patentable subject matters? Then design patents, utility patents, then condition for the patentability, he already told you that it should be novelty, non-obviousness, and the usefulness. Then and then only it will be patents. Then I promise you that I have to tell you how what are the steps to follow file a patent. Okay, so inventor can file a patent in two ways. The inventor can be file the patents on his or her own, जो खुद बंदा है वो खुद कर सकता है, or the inventor can take the help of the patent filing professional or agency. So these are the two ways that we can inventors file a patent. The first step is check if your invention is patentable or not. Before you design the patent, the registration process, you need to check if your invention is patentable or not. This means that you need to check if another individual has filed a patent for a similar technology for which you are filing the patents. Okay, so first thing you have to check. It can save the time and help you to understand whether or not you should file for a patent in the first place or not. Okay, so this is the first step. You have to check your invention is patentable or not. Second, draft the patent application. Once you decided that I can file a patent, then second step is what you have to draft the patent application. Okay, so Indian application needs to file the patent application form 1. For every patent you file, you need mandatorily provide a form 2 patent specification. You can choose between a provisional and the complete patent application based on the stage of invention, and you can apply. You get a period of 12 to 14 months to complete the invention and file for a complete patent. After drafting the patents, you can file the patents application. Okay. First, your patent application needs to be submitted with the several applications form. As per the patent filing procedure in India, you need to submit all the norms and the forms which is available at the www.ipindia.nic.in/form dash and dash phase. When you click on this link, then application for patent grant is a form 1 that you have to fill. Form 2 is patent specification form, which is a provisional or complete. Then form 3 is undertaking and the statement with regards to the foreign application under section 8. In case of corresponding application for patent is filed in a foreign country. Form number 5 is the declaration of invention to be filed with the complete application. Form number 26 is the form authorizing the patent agent. Form number 28 is the mandatory only if applicant is claiming small entity or startup status. And the last is priority documents. You need to provide the priority documents only if priority is being claimed from a foreign patents or the application. Okay, so form 1 for application, form 2 for patent specification, form 3 for undertaking and statement with regards to foreign application, form 5 for declaration of invention, form number 26 for the authorizing patent agent, form number 28 mandatory only if applicant is claiming small entity or startup, and last is priority documents. Okay, if it is a foreign patent. After this step number 3 means after filing a patent, publishing the patent application. That for the publishing of patent application, you have to submit the form number 9, and you have to publish the patent application before the 18-month periods. Okay, and it can be after you have to submit the form number 9. Okay, then step number 5 is what examining the patent application. Means after filing an application of your patent, there is an examination of the patent application. Okay, and it will before you patent is granted, it needs to be examined. Okay, as per the rule of the patent application process, your patent is thoroughly examined based on the merits of your invention. Okay, unlike the publication process, this is not an automatic process, and the applicants need to make a request to examine their patent. And there is a limit. You have to submit your examination details before the 18 months by the form number 18, and there is a section of 18A. When the application lands on the examiner desk, it is scrutinized according to the Patent Act. The patent examiner searches for the similar technologies to ensure that this invention is satisfy the patentability criteria or not. After the reviewing the application, a first examination report, which is called as FER, first examination report, which is called as FER, is submitted, in which grounds for objections, correct, if any, are also stated. And you will get a periods of 6 to 9 months to clarify that objections, and again you have to submit it. Then if the inventor needs to make the changes to his or her objection, he or she can be file a request for time extension by submitting the form number 4. Okay, so this is the step under the examining process. Then after examining, the decision to grant step is there. Okay, means decision to grant patent. Once the examiner finds no objection in the patent's application, he grants the patent. The patent is then published in the official patent gazette. Okay, then the last step of the patent filing is renewing the patent. The patent holder also needs to renew his patent by paying an annual renewal fee. In India, it is possible to renew your patent for a period of 20 years at maximum from the date the patent was first filed. Although the patent filing process is long and complex, one must remember it's important in the long run. The entire process can take anywhere between 3 to 5 years. However, the Indian Patent Office, the IPO, is hiring the new examiners and upgrading its offices to be able to dispose of the patent application. The process is created with the intention of ensuring that the inventor gets credited for his invention. It is also ensure no other individual can claim rights over the invention. Okay, so you can also sue such individuals and claims the compensation for your using your invention without your approval. Okay, so these are the basic steps to file a patent. Intellectual property is an intangible asset. Okay, intangible means not physical. One that can restore the world with an invention that can make life simple and also contribute to the inventor's or his company's growth. And intellectual property brings with it a whole lot of benefits. It can turn an idea into a profit-making asset, enhance the market value of a business, and even help to raise the finances. The various inventions such as solar power trees, solar water power purifiers, cane-based lamps, and the self-repairing roads have all been created to Indian investors. These inventions have truly changed the world. Okay, so that's it. If having query, it is open for a question. Thank you, sir. Very nice
Thank,
session. Very
thank,
nice session.
thank you, sir. Thank
But
you very much.
some of it is, and it is a new topic to the students.
Very much, sir.
So, if required, so I will share the PPT and the steps for filing a patent. So I will share with you if required. Okay.
Okay, sir. That would
Okay.
be of great help, sir.
Yes. Yes.
Sir, can
So
you
basically,
share what is the fees or what cost we can incur for?
yes, sir. I will share, sir. No issue.
Okay, sir.
Recently, I have filed a patent and it's published, so I will share the all the details with you, sir. No issue.
Okay.
Okay.
So I would like to take questions from the participants. Any of the participants, you can write it on the chat box also. think there are no questions from the participants. Any of the
Okay.
participants?
So I think so.
Yes, please.
There are only two answers to this question. If all is getting to all, and nothing is getting to all, only these two answers to question.
Actually, the topic is very
So
new to them. They are
yes,
not
sir. And so
familiar
I
with them.
asked, how their students are from which years, second, third, final, and all.
There are students from the first year also, second year also, and the final year also, sir.
Okay, okay, okay. And sir, if you are having incubation center at
Yes, sir.
your,
Innovation Cell. We are conducting this program.
you are having innovation sale.
Yes, sir.
Okay, sir. And have you registered as a Section 8 company for the same?
No, 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 sir. Till now,
Okay,
not.
okay, sir. Okay. So can we have a photograph at last, sir?
Yes, sir.
Can we have a photograph at last?
Yes, sir. Sure, sure. Okay. Any of the participants having any questions?
At last, my mail ID is also there. If you
Yes,
have
sir.
any query or that, you can ask to me on the same mail ID.
Surely, surely, sir. I will also share them your mail ID so that
Yes, yes, sir. Yes, sir.
they can contact
No issue.
after. I would like
Yes.
to ask the participants to go through the topic once more.
Sir, I will share the PPT to
Okay.
you. Send
Okay.
it to your students group. Okay, if they have any doubts, so I having you having my mail ID,
Yes,
so you
sir.
can drop me a message on WhatsApp or you can drop me a mail. I will
Okay, sir.
clarify the query related to startups. Sorry, that IPR.
Okay.
Okay.
Okay. Okay, sir.
Okay, okay, sir.
Okay.
Thanks for giving opportunity
It is
to
our honor, sir,
give
to have you, sir, among us.
no, sir. Actually, it's what after official time. Now we having 5:30 is what official time today.
Okay.
So all the students are having patience to also have after the college time. So it is very good. No issue. Okay, sir.
So with this, I would like to conclude the session. So once again, from our institute on behalf of ourselves, I thank you, sir. Thank you for giving us
Thank
your time and sharing the knowledge and the process of patent filing. And we would
you. Yes, sir.
looking highly for filing some patents from our institutes also with your help. And
Yes, sir. Yes, sir. Sure.
yes, sir.
I will
So
help. It is our duty, sir, to help all the student, all the startup entrepreneur to have their startup areas, and
yes, sir.
it is our duty, sir.
Thank you, sir. Thank you very much,
Okay,
sir. Thank
thank
you.
you. Okay, thank you, sir.
Okay. Thank you, all the participants. Thank you very much for your patience. So we are ending the session now. Thank you again, sir.
Thank you, sir. Thank you.
Thank you. Thank you, sir.
Okay, okay.